I have the great pleasure and privilege of introducing my friend Peter Wallison. And actually, getting to introduce Peter wasn't easy because Mike McConnell and I had to fight over it because actually Mike has known Peter longer than I have, I found out, since the 1980s. And I got to know Peter in the 1990s. But I think that the fact that we both would have been very happy to introduce him illustrates why he's such an ideal choice for our lunch speaker. Peter is by training a lawyer, but his title at the American Enterprise Institute right now is the Arthur Burns Scholar in Financial Policy Studies, which doesn't even sound like a lawyer to me, because Arthur Burns certainly wasn't. Of course, some would say he wasn't much of an economist either, but that's not true. He was a good economist. Although he advocated price controls and many other things that economists generally don't regard as a very respectable occupation. But anyway, and he oversaw the rise of inflation and a lot of other pretty crazy things. So you've got a lot of explaining to do for your title, buddy. Yeah. Anyway. But Peter really is that ideal manifestation of mixing deep understanding of law and deep understanding of economics in ways that can result in advancing public policy. He has a very long and rich resume, and I'm only going to touch on a few of the main points. He was White House counsel under Ronald Reagan. You may have remembered the Iran-Contra controversy, and I have a feeling that Peter also remembers it.
It's a low point.
Yeah, he was general counsel of the Treasury also in the 1980s. His public policy service goes way farther back when he was still in grade school in the 1970s working with Nelson Rockefeller, a name that many people remember as a Republican when there was such a thing as Rockefeller Republicans. He spent most of his professional career, I guess I could say most, as a lawyer, especially at Gibson Dunn, where he was really the leading light of their financial institutions and practice and other things for many years. And I can also say that my personal enjoyment with him began when Chris DeMuth and I will take part credit for it, brought him to the AEI, and he and I served together as the co-heads of the financial regulation area at the AEI for many years. Most recently, he was famous as a member of the Financial Crisis Inquiry Commission and published a very influential opinion that differed, and I would say in very insightful ways, from the majority opinion. And then wrote a book that has done very well called Hidden in Plain Sight, about his take on many of the things that led to the crisis of 2008. He has a new book, which we're going to hear about today, called Judicial Fortitude, and I'll leave it to him to explain the title and the point of the book. Peter, you have about a half an hour, and then we'll save about 15 minutes for Q&A. So welcome.
Thank you, Charlie. Can you all hear me? Is this broadcasting? Okay. Well, Charlie and I really do go back a long way, and I kind of keep him in my memory because when I came to AEI, Charlie was already the director of the program on financial policy studies, and Chris, who I now see is here, hi Chris, was uncertain about how to handle this problem because he had this superb person working on financial policy studies, and the only thing I really knew anything about at the time was financial policy. So Chris asked me whether I would mind being the co-director of the financial policy studies program, and he asked the same thing of Charlie, and Charlie had no problem with that, and neither did I. Charlie then left AEI, and I am still the co-director. I've kept him in my memory by calling myself the co-director, and some people have asked me from time to time, well, who's the other? Who's the co-director? And I'd say, it's Charlie Calomiris. And they'd say, well, who's he? They're not they're not economists. All right, well, I'm going to talk today about something that is actually very, very closely related to everything I heard this morning, and I'm delighted that it is. I didn't realize when Charlie invited me that it would be so closely related, but it has to do with executive lawmaking, with the weakness of Congress, and the rule of law. And it is this book that I have recently published called Judicial Fortitude, and I think you will understand what the title means and where it came from. But Judicial Fortitude, the last chance to rein in the administrative state. The book begins with this sentence: "It is not too much to say that we risk our democracy unless we can gain control of the agencies of the administrative state." Now, this is not the way most Americans, even most students of administrative law, think about the growing power of federal administrative agencies, but to my mind, that is the real issue raised by the extraordinary growth in the importance of these agencies. It is a threat, they are a threat to the Constitution's separation of powers, and thus, ultimately, a threat to liberty. Over 200 years ago, the framers of the Constitution designed what can best be described as a democratic republic. More important than the Constitution's structure, however, is that most Americans believe they live in a democracy or a democratic republic, and thus that ultimately they have the power to control what the government does. This belief is the source of the government's legitimacy. That is, its moral authority to demand obedience to its laws. We Americans voluntarily obey the laws because we, in a way, participate in making them through voting for Congress. But as more and more of the rules seem to be made by unelected officials, there is a danger that the government's legitimacy will be subject to question. We have seen this happen elsewhere. In 2016, a popular movement in Great Britain called for a referendum on whether the country should withdraw from the European Union. Nicknamed Brexit, one of the program's principal complaints was that the British people were being governed by a group in Brussels over which they had no effective control. Britain, of course, is a democracy like ours, and its population is accustomed to believing that the government will respond to what they want. Despite the claims of many in Britain's leadership that departure from the EU would be catastrophic for its economy, a majority of Britons voted to leave in 2016. This is an example of what happens when a government, in this case the European Union, loses its legitimacy. Those who think it can't happen here, that no substantial number of people in the United States feels disenfranchised, have not fully taken on board the meaning of the Trump election in 2016. That vote has been called a populist uprising, and it certainly was, just like Brexit. And at its source, like Brexit, was a growing sense among a large portion of the American people that the U.S. government no longer represents them or their priorities. The popular claim that President Trump will drain the swamp encapsulates the contempt with which Washington is held. If this trend continues, and it shows no likelihood of abating, it raises a Brexit-like question of the legitimacy of the United States, at least the government. The challenge then is to develop a way to limit the growth of the administrative state so that it is no longer seen, as many see it now, as an out-of-control government, issuing rules and regulations that reflect the views of the bureaucracy in Washington and not those of the American people. We have obviously drifted from what the framers initially designed, and that has occurred even though the framers included elements in their plan that were intended to keep the original structure intact, or if necessary, restore it. Today our task is to get these mechanisms to work, and that's what the book is about. As we know, the Constitution creates a government of separated powers. Congress has the sole power to make the laws. The President and the executive branch have the sole power to enforce the laws, and the judiciary, as Chief Justice Marshall said in Marbury and Madison in 1803, the judiciary has the province and duty to interpret the meaning of the laws. By separating the legislative power from the executive power, the framers hoped to prevent both lawmaking and enforcement from falling into the same hands. They had just secured their independence in a world in which kings could both make the laws and enforce the laws, and from their perspective, it seemed as though that was the source of the tyranny that they were observing around the world. Under the Constitution, accordingly, apart from certain specified powers provided to the President by the Constitution itself, neither the President nor any agency of the executive branch could act without the authority of a law passed by Congress. Logically, then, Congress cannot delegate to the President or any agency of the executive branch the lawmaking authority that the Constitution reserved for Congress alone. To do so would nullify the purpose of the constitutional separation of powers. The framers, however, recognized that the Constitution was only a piece of parchment, and that its essential structure could be compromised over time as the government responded to the pressure of events. To prevent this, they created a system of checks and balances so that each governmental branch had some ability to interfere with the actions of the others. For example, Congress could enact a law, but the President could veto it. The President could make a treaty, but the Senate would have to approve it. And Congress could appropriate funds for both the executive and the judiciary. The checks and balances were obviously intended to create a basis for bargaining among the branches, because each could significantly interfere or obstruct the purposes and objectives of the others. Underlying this strategy was the assumption that each of the branches would be jealous of its powers. But there are indications today that this assumption was wrong. Far from an independent branch, the modern Congress has become a kind of appendage of the President and seems eager to hand over its legislative functions to the executive branch, especially when both are controlled by the same political party. However, the framers inserted another device into the constitutional system to ensure its survival. This device was an independent judiciary. In Federalist 678, one of the many articles the framers wrote in support of the ratification of the Constitution, Hamilton called the judiciary the guardians of the Constitution. It's easy to see, he wrote, that it would require an uncommon portion of fortitude in the judges to do their duty as faithful guardians of the Constitution where legislative invasions of it had been instigated by the major voice of the community. Interestingly, yesterday, the Supreme Court reported a decision in a case called Gundy versus United States. And this quote from Hamilton appears in Justice Gorsuch's dissent. And he made clear in that dissent, and I'll tell you about the case later if we have some time. I don't want to go too far over the time available. The case is a little complicated to describe. But in other words, the Supreme Court, at least in the form of Gorsuch, Roberts, and Thomas, who all dissented from the decision of the court in that case, which denied that the case was a non-delegation case. They all dissented. Kavanaugh did not participate because he hadn't been sworn in at the time the case was heard, so he couldn't participate in the discussion. And Alito said, well, unless there's a majority willing to go ahead with this non-delegation idea, I'm going to agree with the decision of the four liberal justices, and that decided the case 5-3. But what this means is that if Kavanaugh is of the same view of the constitutional issues here as his fellow constitutionalist judges, there will be 5 judges then, 5 justices on the Supreme Court who are going to be willing, apparently, to invoke the non-delegation doctrine. So that's key to what is in this book, and I want to explain then why Judicial Fortitude has the title Judicial Fortitude. That is, the court must have the fortitude to step in this very difficult area. The guardians of the Constitution, says Hamilton, and the reason that the justices and all judges got lifetime appointments, lifetime tenure, was to give them the fortitude to protect the Constitution's structure. So that's the essence of the argument I'm making in this book. To provide the judiciary with the necessary fortitude, Hamilton argued, the Constitution provided that the judges would be appointed for life. Now that we have a problem just like this today, where the separation of powers is being challenged by the willingness of Congress to hand over its legislative powers to the executive branch, the question is whether the judiciary really has the fortitude to act. Acting would mean nothing less than preserving the separation of powers by declaring in appropriate cases that Congress has unconstitutionally delegated legislative authority to the executive branch. The difficulty of making a decision like this should not be minimized, not least because it is extremely difficult to define the line between legislation, which is the exclusive jurisdiction of Congress, and administration or execution of the laws, which is the exclusive province of the executive branch. Yet, and this is really important and why it has to be addressed, yet if we are to preserve or restore the separation of powers, where both the power to make the laws and the power to enforce them are not held by the same person or group, this must be done. Perhaps because of its difficulty as an intellectual matter, and the certain criticism which the judiciary would be subject if the courts entered this thicket, the Supreme Court has avoided the task of defining this line for more than 200 years. And as a result, the agencies of the executive branch, empowered by broad legislative-like authorities from Congress, have increasingly become the rule makers and lawgivers for our society. In 2017, for example, Congress enacted 94 laws, but administrative agencies issued more than 3,000 regulations. And in fact, that has been true every year since 1993. So in that 25-year period, over 101,000 rules and regulations have been issued by the agencies of the executive branch. To be sure, there have been many cases where the judiciary has stepped in to curb actions by Congress or the President that, in the Supreme Court's view, exceeded their respective powers under the Constitution. For example, the court declared laws unconstitutional as early as 1803 and invalidated an effort by the President Truman to use his presidential war powers to take over the steel industry during wartime. But defending the separation of powers by declaring that Congress has unconstitutionally delegated legislative power to the executive branch is very different and from these important and controversial steps. Taking the power from the executive and restoring it to Congress would be a massive change in the way the government acts today, angering the president, whose administration would lose power, and Congress, which has found that by delegating its powers to the executive branch, it can conveniently avoid the difficulties of legislating. Politically, such a step would also strongly be opposed by the left, which likes the policies implemented by the agencies of the administrative state and doesn't seem to care that they are not democratically initiated. Indeed, far from exercising fortitude, until today the Supreme Court has gone the other way, allowing the agencies of the executive branch to take over more and more of the authority of Congress to make the major decisions for society. In other words, to engage in lawmaking. How did we come to this point? For its first 150 years, the system designed by the framers functioned as it was designed, functioned well. Congress, as the framers expected, jealously guarded its legislative authority during this period and doled it out only sparingly to the president and the executive branch. But with the Great Depression, the election of Franklin Roosevelt, and the advent of the New Deal, the relations between the judiciary and the elected branches began to change. Responding to FDR's request, Congress voted to give extraordinary regulatory and administrative powers to the presidency and the executive branch, and many new agencies were created and given broad authority to oversee and regulate major portions of the economy. These new relationships raised in very stark form the question whether Congress was delegating excessive power, unconstitutional legislative power, to the executive branch. And finally, in 1935, for the first time, the Supreme Court nullified two laws enacted by Congress on the ground that they were unconstitutional delegations of legislative power. Both decisions were highly controversial, as Hamilton foresaw, and were seen by many as the judiciary interfering with the president's efforts to combat the Depression. In the election the following year, 1936, FDR won a smashing victory, and after that seemed to retaliate against the court with a plan to increase the number of associate justices from 8 to 15, which would have allowed him to take control of the court. This was the court packing plan, as it was called, and was unpopular with the public and was never enacted by Congress. But it seemed to cow the court, which never again declared a law unconstitutional because it delegated legislative power to the executive. As important, beginning in 1937, the justices of the 1935 court began to retire, and between 1937 and 1941, FDR was able to appoint 7 new justices and a chief justice, all of whom supported his policy of regulating the economy by creating new agencies and providing them with broader authority. The precedents for expansive administrative authority established in this period have influenced decisions of the court to this day. And in 1984, following out the idea that administrative agencies should have more discretionary authority, the Supreme Court decided Chevron versus National Resources Defense Council, which directed the lower federal courts to defer to agencies' interpretations of their statutory authority, if those interpretations were reasonable in terms of the policy Congress seemed to be enacting. That ruling gave a major boost to the growth of the administrative state because it enabled federal agencies to use in new ways laws that had been enacted for other purposes in the past. In addition, with agencies assuming more powers, Congress found it convenient to enact very general laws, directing agencies to achieve certain goals without Congress having to make the difficult and controversial decisions that legislation actually requires. So agencies were directed, for example, to assure that our water is clean and the air is pure, but without deciding who is to bear the costs or whose property is to be burdened by the resulting restrictions. These laws, in effect, pass on to the agencies of the executive branch the very difficult decisions, imposing costs, and taking away benefits that in a democratic society should only be made by the legislature, by Congress. Administrative agencies then have in many cases been able to supplant Congress as the nation's lawgivers, even though they are headed by unelected officials without the inherent power to make the major decisions involved. Of course, in the ordinary case, the role of administrative agencies is to fill in the details of a more general statute that Congress enacts. So, for example, if a statute says that employers must pay overtime to any employee who works more than 8 hours a day, the agencies will define overtime, employee, and day. But too frequently, agencies go beyond filling in the details and interpret the language of their authorizing statutes to cover things that Congress didn't intend. When they do that, they are clearly taking over a lawmaking power of Congress. Now, there is no way of getting around this. As long as we have a system of separated powers in which Congress is supposed to make the laws and the agencies of the executive branch are only authorized to enforce the laws, Congress cannot delegate its legislative authority to executive agencies, nor can agencies be allowed to interpret the statutory authority they have been given so that their authority extends further than Congress actually intended. Both steps would do what the framers sought to prevent, combine in one body both legislative and executive power. Yet this appears to be happening under the Chevron rule, where courts have to defer to agencies' interpretation of their own powers. In 1972, for example, Congress enacted a series of amendments to the laws governing the federal government's financial support of colleges and universities. This is just one example in the book. One provision of the statute provided no person in the United States shall, on the basis of sex, be excluded from participation in or denied the benefits of or be subjected to discrimination under any education program or activity receiving federal financial assistance. This language, which Congress intended, this was 1972, to prevent schools from discriminating against women in such matters as college admission, curricula, and sports, has been used by the Department of Education to prescribe how colleges and universities must react to sexual harassment between students. In other words, a law that was intended to ensure that women were given the same educational opportunities by schools was used for something entirely different, a law that covers how students treat one another. Under its rules, the department has prescribed how schools must treat those who are accused of sexual harassment. They've defined sexual harassment, including the kind of trial that must be held and the amount of evidence that is required for a finding of harassment. All of this was spun out of a law that began as nothing more than an effort to ensure that women were not discriminated against in providing educational resources. Here is the crux of the matter, and the reason that there have been more than 3,000 regulations every year. With the courts allowing it to happen, the agencies of the administrative state, like the Department of Education, have been able to broaden their authorities beyond what Congress actually enacted. The deference to agency interpretations of their statutory powers, authorized in the Chevron case, has contributed to this problem. But so has the fact that the courts have never tried, except for two cases in 1935, to define the line between legislation and administration. Accordingly, it is the failure of the courts to make these difficult decisions, a failure, if you will, of judicial fortitude. That has enabled the agencies of the administrative state to become lawmakers instead of simply law administrators. As Hamilton pointed out in Federalist 78, the members of the judiciary were given life tenure for a reason. In effect, if nothing else worked to preserve the separation of powers, the judiciary was to be the fail-safe mechanism. With the separation of powers and the democratic structure of the government now in some jeopardy, this appears to be the time for the judiciary to intervene. But the judiciary's role here is and should be limited. It has no constitutional authority to intervene in the making of national policy, and it must adhere to the principles of judicial restraint dealing with the laws enacted by Congress. But preserving the Constitution's structure, the framework within which the framers designed to protect the people's liberty, is a special responsibility of the judiciary. Judicial restraint, accordingly, is not applicable in this case. In addition, the Supreme Court will have to begin restoring the non-delegation doctrine, the idea that the courts will invalidate laws that delegate legislative authority to the executive branch. The separation of powers is meaningless if the courts do not attempt to define the difference between legislative and administrative actions. And if the separation of powers is meaningless, so is the protection of liberty that the framers sought to achieve by preventing lawmaking and law enforcement from falling into the same hands. If the courts follow the course I am recommending, Congress will be forced to meet two different tests. The statutes it enacts will have to be specific enough so that a reviewing court will be able to determine how much authority Congress intended to give to the executive branch agencies, but the authority cannot be so broad that it enables the agency to assume the exclusive legislative power of Congress. As a result, Congress will be forced to perform the vital role of legislating, deciding who benefits and who is burdened by the policy decisions it makes, and will not be able to leave those decisions, as it has been, to administrative agencies. This will prevent a Brexit-like loss of legitimacy for the U.S. government. The good news, from the perspective of people with my views about the administrative state, is that there are now 5 members of the Supreme Court who call themselves constitutionalists and believe in the importance of the separation of powers. This includes Justice Roberts, who in a 2013 case both proposed to modify Chevron and noted that, quote, the obligation of the judiciary is not only to confine itself to its proper role, but to ensure that the other branches do so as well. This is a clear restatement of Hamilton's view of the judiciary as the guardians of the Constitution and the separation of powers. There is no doubt that these decisions about Chevron and the separation of powers, if they are made, will be controversial. Many groups, especially on the left, like the policies of the bureaucracies in Washington and have no concerns about how they are made by unelected officials. For example, in October 2018, Eric Posner, a professor at Chicago Law School, made clear in a New York Times op-ed exactly how the left will oppose any decision by the new conservative court to modify Chevron and implement a more limited role for administrative agencies. The real question, he wrote, is whether the Supreme Court will undermine the system of government that has protected the public from abusive business practices since the New Deal. Thus, explaining why it is necessary to restore the separation of powers will be a legal challenge for the court and a political challenge for those who want to limit the power of the administrative state. In the coming controversy, the lodestar must be that the framers designed a system in which the people, through an elected Congress, not unelected bureaucracies, must make the major decisions for society. Efforts to keep power in the hands of the administrative state are really efforts to substitute the priorities of government bureaucracies for the priorities of the people. Therefore, even if the American people agree with some of the decisions of administrative agencies, as they surely will, they will also have to understand that we cannot survive as a democratic republic unless these decisions have first been authorized by Congress. Thanks very much.
Peter, in your discussion of delegation, you didn't really make any distinctions between delegation to administrative agencies and to the traditional executive. In other words, delegation to the Labor Department as opposed to delegation to the Securities and Exchange Commission. So do you think there's any important, from a legal standpoint, any important difference there?
No. I meant all agencies, hundreds of agencies, not just the so-called independent agencies that are sometimes thought of as a special group. They actually fit in pretty well with what happens under the Constitution and the structure of the government that the framers had in mind. And the major cabinet agencies are doing most of the rulemaking. Most of the rulemaking is done by Treasury, by Health and Human Services, by Education, those cabinet agencies. And so that's where these 3,000 regulations each year are coming from.
So I'm Price Fishback. I'd like to speak about the two New Deal cases you talked about as being delegation cases. To me, those delegation cases were not delegation to administrative state. The NRA case was a delegation to the corporations themselves and the other people to self-regulate it, essentially. And then the Butler case about the AAA was about the tax, and you couldn't tie the tax to paying farmers to take land out of production. So I don't really see that as about delegation to the administrative state, as basically other kinds of limits on what they're doing.
I'm sorry, but I didn't cite those cases.
You talked about the two
cases. The two
So which
cases
two?
where the court declared that there had been an unconstitutional delegation to the president.
Okay,
that
what were
was-
the two?
And the two cases were, yes, Schechter and Panama.
My understanding of
Refining in
Schechter is
1935.
that was delegating to individual firms and things like that. That was my understanding of it. It wasn't necessarily administrative state.
No, in both cases it was power to the president. These were delegations to the president, and not even to an agency in particular, but the president was given the power to make decisions in both cases, Panama Refining and Schechter.
Garrett Snedeker with the James Wilson Institute. I want to just come back to one of the final points that you made, Peter. It was about how we are to confront the argument from professors like Eric Posner that rolling back the administrative state is going to have real and definable costs to the average voter. And while I think a lot of us are persuaded by Justice Scalia's arguments on the separation of powers having substantive value and the protection of liberty, we are going to have to confront that question about what does it actually mean to roll back the administrative state. So what I'd like to ask you is how would you confront arguments such as the question of the regulation of big business, because on its face, at least to me, we're just as likely to be suffering from regulatory capture as we are to be living under a regime in which big business is being reined in. So I'm curious your thoughts on how our political class might be able to talk about this, not in as much an intellectual exercise or a speculative exercise on the structural protections of liberty, which are, I think, quite intelligible, but more on how we can communicate this to the average voter.
That's why I emphasized at the beginning the loss of our democracy if we don't deal with this problem. Because if things continue to go over time, as they have over the last, 40, 50 years, we will eventually be governed entirely by this political class or this administrative class around Washington, D.C. And so I've tried to frame my argument as a question of democracy, that is the people governing, as opposed to government by this unofficial group of people who are peopling the administrative agencies. Most people do talk about it in terms of liberty, and I think that's a little too abstract. What is important is democracy, people's understandings that they control the government, and then looking, if you want to broaden it a little bit beyond that, you look at Brexit. And you say, gosh, if the American people come to believe that they no longer have control over their government, that these rules are coming out of Washington, and they don't have any idea how they originated and why these rules are being imposed on them, we get a problem with the legitimacy of the United States government. No one can, the people can't withdraw from the government, it's not like Brexit was, but they can stop thinking that they have to obey the laws because the moral authority of the government has been destroyed.
It struck me that when you said you need to draw the line on delegation of authority. but you weren't very explicit about where you draw the line. And that's the nature of the problem, isn't it? I mean,
Yes.
when Congress creates a law to deal with a social problem, like pollution or something, and they don't have the expertise to fully define what it is, then they delegate authority to somebody else to figure out the span of the problem. So how do you create an apparatus that draws a line? And then what do you mean by what Congress intended? Because you use that word too.
This line drawing problem is a severe problem. I have no answer for it. And as I said in my talk, one of the reasons the court has tried to escape that issue by using other ideas for describing why a delegation of legislative authority hasn't occurred is that they have been afraid to enter this field. And with justification, because they know that once they enter the field and start talking about where this line is or what is legislation and what is administration, they will be deluged with many efforts, many cases where they're going to have to try to draw that line again. I analogize it a bit to what happens with, say, or has happened with an unconstitutional search and seizure. We don't know what those words mean, unconstitutional search and seizure, but after the court has done jurisprudence on them for 70 years or so, we know enough about the answer so that what can happen is that policemen on the beat can be instructed what they can and cannot do. The same thing can happen if the court deals with this issue of legislation versus administration. It's also done it with certain other things such as void for vagueness and so on. It takes time for the court to go through case after case with facts that they make a judgment about. And if they can do that, and it's going to take a quarter of a century probably if they start, it will result in people having an understanding and Congress having an understanding of what they can do or what they must do and what they can send over to an administrative agency. But I don't think anyone has an answer to it right now. But it's in the Constitution. There's supposed to be a separation between legislative power and executive power. And unless we modify the Constitution, we will always be living with this tremendous intellectual problem.
Alexander Kahn. So in most, if not all, of the non-delegation cases that have come before the court has expressed a concern for respecting Congress's role as a co-equal and independent branch, specifically in terms of their ability to determine the constitutionality of the bills that they're passing. And you spoke briefly about judicial restraint, but I'm wondering how, in your opinion, justices on the Supreme Court are supposed to balance that respect that is due to Congress with the need for judicial fortitude in this area.
Well, I think that what the court has to do is to realize that in this case it is dealing with the structure of the Constitution. This isn't the ordinary issue of policy where judicial restraint is necessary. They are dealing with something that the framers left to them, wanted them to do, according to my analysis of what Alexander Hamilton was talking about in Federalist 78. They are the guardians of the Constitution, and so they have to step in now and make a judgment to prevent Congress from doing things that are in violation of the Constitution structure, and that would be delegating legislative authority, whatever that is, and I can't say what it is, but delegating legislative authority to executive agencies.
Let me ask a final question just to follow up on the question Bob Topel asked. So it seems to me like there are many different processes that can arrive at this conclusion. You don't have to, as a proponent, have the magic wand answer for where this dividing line is. Let me give you an example. If you just got rid of Chevron deference, then what that immediately does is it creates risk for any regulation. It means that now it's not automatic that there's going to be deference, And then, so Congress can no longer have its cake and eat it too. It can no longer have a rule exist and not have to worry about going through the messy process. But that could just be solved by congressional review. It doesn't have to be solved by congressional actual initiation of the rule. Congress could still leave it up to experts, but then have the burden of having to review the rule afterwards, right? So it doesn't require Congress to necessarily make all the rules in advance, but it requires Congress to take responsibility for the rules ultimately. Isn't that true?
Yeah, that would be a solution, but when we're talking about 3,000 rules a year and a Congress that can barely pass anything, it's not a realistic solution to the problem, I think, although many people think it could ultimately be. So I think the only way really to address this is for a jurisprudence of non-delegation, where the courts actually look at something like this. Now, if we just go in for a moment to the Gundy case, this was a very close case. The court took it, I think, because they thought the only argument that they were interested in was the argument that this was a delegation of authority, and what it had done, what Congress had done, was given the Attorney General the power to decide what people who had been convicted, sex offenders who had been convicted under state laws, would have to do to register under the new federal law. And it seemed as though the Attorney General was given quite a lot of discretion on that. And there was nothing in the statute that could be considered a restriction on his discretion. But the four liberal justices, in an amazing amount of I guess statutory construction, found something that would be a restriction on the Attorney General, and decided that this was not a delegation case. Then, as I mentioned, Justice Alito went along with them because he's ready to take on a case where there's a majority for treating something as a delegation case, but this wasn't a majority. With Kavanaugh in it, if Kavanaugh is of like mind with his colleagues, yeah, there might be 5 votes that Congress has delegated legislative authority. And if there is such a thing, then we go on to all of this jurisprudence of non-delegation, because that happens naturally. As soon as lawyers and clients understand that this issue is up in the air and is going to be decided by the Supreme Court, there'll be plenty of cases coming along and making that argument. So I think that's, if it happens, we will in the next 15 or 20 years have a number of these cases coming along. And I want to mention one other thing about how this will be done, and then we're out of time, I know. And that is the Congress uses something called the Congressional Budget Office to do economic analysis and to tell them what the effect of their legislation might be. It's not inconceivable that they could have a group of lawyers who are employed specifically for the purpose of interpreting what the Supreme Court has said about what is legislation and what is administration, and would tell the Congress, you have to word this statute differently because you have to take more responsibility here than you are, and you are giving too much discretion to the agency. That would be an analog that would be workable, it seems to me, but it would have to be done after the court decides to put Congress into this cage.
Well, please join me in thanking Peter for that very excellent talk.